Hello, Madam Speaker, Mr. Speaker. Mr. Speaker, you know, when I saw a black man, I just knew things have changed. So, Mr. Speaker, I want to bring to the attention of the House a matter that is very important. Mr. Speaker, as you are aware, the issue of our main business here is legislation. And one of the biggest predicaments that we have faced on issues of legislation, Mr. Speaker, is the issue of public participation. Public participation. So, Mr. Speaker, I want the House to take note of the ruling of the Supreme Court that happened the other day, Mr. Speaker, on the finance bill that was suspended by the court, Mr. Speaker. And the bench at the Supreme Court did a very thorough work, Mr. Speaker. And I want to congratulate them because they have laid basis and foundation now for a proper public participation, Mr. Speaker. Mr. Speaker, I want to urge members to read that judgment, Mr. Speaker, because that judgment has really, really helped this country. It has cleared the path for this country now and for Parliament to do proper legislation, Mr. Speaker. Mr. Speaker, for the last 10 years or so, since the new constitution was enacted, Mr. Speaker, Parliament could not do this business, Mr. Speaker. Any legislation we do here, any act that is assented to by the President, Mr. Speaker, somebody goes to High Court and the High Court declares that act unconstitutional, Mr. Speaker, when in the actual sense, an act could have 73 or even 80 clauses, Mr. Speaker. And instead of a judge declaring the 10 or 15 clauses that someone has a problem with, many times judges have declared acts of Parliament unconstitutional, Mr. Speaker. If you read the judgment of the Supreme Court now, Mr. Speaker, and I read that judgment last night, it gave me a lot of hope. And I said I must bring to the attention of members that now the country is going to the right direction in terms of legislation. The Supreme Court said, one of the best things the Supreme Court said is that Parliament doesn't have to convince the public on what they are doing or the legislation. They just need to inform them. Information, Mr. Speaker. You don't have to convince because we are here to legislate on behalf of Kenyans. We are exercising sovereign power that is delegated to us, Mr. Speaker. So the Supreme Court, in their own wisdom, said that you just need to inform the public. You don't need they don't have to agree with you. Because legislation is not being done in the public, it's being done in the floor of the House. One of the things that has shocked me about public participation, one time, one of the judges declared one of the acts unconstitutional. And he said that the advert that was released to the public was done in English and not Swahili. And himself is doing his judgment in English. He did not do it in Swahili, Mr. Speaker. So, Mr. Speaker, without belaboring the matter, time is ripe now for the public participation bill to come to this floor of the House. The Supreme Court has spoken on it. The Supreme Court has cleared the path. Now we need to get a proper public participation bill on the floor of the House so that we can dispense off with that matter once and for all. Kenyans have suffered. Kenyans have suffered in the sense that any legislation that is made by the representatives is normally declared null and void and unconstitutional by the courts, Mr. Speaker. The courts are legislating through, I don't know how to describe it, through the back door, Mr. Speaker. So, Mr. Speaker, that matter must come to arrest. But I want the majority leader to weigh on this matter. And I also have the issue of femicide, Mr. Speaker. Femicide. Our women are being killed, Mr. Speaker, Kenyeji. Even today, there is one that has been killed and her body parts thrown at Isli, Mr. Speaker. At Isli. Another one, Atlangata. But her origin is from Isli. So, Mr. Speaker, that matter also we need to talk about it, but let the majority leader pronounce himself on the issue of the Supreme Court and public participation. Thank you.
Thank you, Honorable Speaker. Let me first commend the Leader of Minority, the Honorable Junet Mohammed, for raising this issue on the matter of the judgment, and also take this opportunity to commend the Supreme Court. Because, Honorable Speaker, the architecture of a constitution, and we must thank God that under the 2010 Constitution, the Supreme Court came into being. Because, Honorable Speaker, as an advisory court also, they have now set the pace, as the Honorable Junet Mohammed says, for us to be able to enact substantive legislation to guide our public participation exercises in the legislative processes of this House and even those of the other House and our county assemblies, Honorable Speaker. Honorable Speaker, I want to agree with the Leader of Minority that in line with Article 2 of our Constitution, that says that the people may exercise their sovereign power either directly or through their democratically elected representatives. And those democratically elected representatives are the men and women who sit in this House and in the Senate, Honorable Speaker. And more so in this House, because it is this House that represents the people. And that is why you will find also in this Constitution, many of the bills that become law can emanate from this House and become law without going to the other House, to the Senate, Honorable Speaker, because we represent the people while our Senate colleagues represent our counties. And that is why those bills that touch on counties and county governments must, as a matter of the Constitution, go to the other House and may also emanate from that House, but must be completed in this House. And that is why I've always argued, Honorable Speaker, since 2013, when we began this new system with the bicameral parliament, that we don't need to belabor which House is superior to the other. If one House can enact legislation and it becomes law by itself, and the other House cannot enact legislation and it becomes law by itself, it has to go to the other House, then it goes without saying which House is the upper House, Honorable Speaker. But that is not the point, Honorable Speaker. The point is that public participation has been abused by a number of our judges, especially in the High Court. And I must commend the Supreme Court and those other judges who have exercised judicial restraint in making determination as to what constitutes good public participation. And I've read previous judgments on qualitative and quantitative analysis of what is good public participation, Honorable Speaker. But the Supreme Court now has put it very well. And I want to agree with Honorable Junet that it was misconstrued that public participation is a referendum. And in fact, during the public participation exercise of the impeachment process of the former deputy president, there are those who argued that way. And there are those who believe that we are going to carry out a referendum exercise. Public participation is to go out and collate the views of the public. But it's still up to the members of parliament to consider the views of the members of the public. And they may not necessarily be the right views. And you know, Honorable Speaker, it is said that opinions are as many as, I don't want to say what they say out there, but you know what they say, that opinions are as varied as you know what. And everybody has theirs. Therefore, as many views as we will get from the public, Honorable Speaker, the onus is still on us as the lawmakers to consider all those views, balance those views against what the legislation that we are making seeks to achieve, Honorable Speaker. And I'll take you back, Honorable Speaker, to the Finance Bill 2024. And Honorable Speaker, because I have seen the CS of National Treasury bring in a number of proposals that were very good proposals that were carried in the Finance Bill 2024, Honorable Speaker. We went out to collect views of the public through the public participation exercise that the member for Molo, the Honorable Kimani Kuria, spent, I think, close to 14 days seated in County Hall, listening to Kenyans. And Kenyans came in their numbers to give their views. They said they do not want taxation on bread. They said they do not want to see taxation on motor vehicles. Kimani Kuria and the Finance Committee did a report which was tabled and adopted by this House in second reading, agreeing with members of the public that there should be no taxation on bread, no taxation on motor vehicles. Kenyans out there from the manufacturing industry, Honorable Speaker, industry,
appeared before the Finance Committee and told them that we are killing our manufacturing industry in Kenya because we are encouraging more of imports than local manufacturing. And it was players in the manufacturing industry through KEPSA, through the Kenya Association of Manufacturers, that brought proposals that would protect our local manufacturing industry, made proposals to levy excise duty on completed or finished products being imported from China, the Far East, Europe, including diapers and sanitary towels. But what happened, Honorable Speaker? The public were incited to believe that this House was levying tax on all diapers, on all sanitary towels, and you remember our young daughters telling us in their parlance out there how our bunge hata hawataki tunyeshe sasa. You know, Honorable Speaker, how embarrassing when we saw it was when we watched our daughters, our teenage daughters, telling us that hatutaki wanyeshe. Whereas it is them that we sought to protect. It is our young mothers, our young daughters, our sisters we sought to protect from cheap, completed products of sanitary towels, which nobody can authenticate how hygienic they are. The standards that they've been manufactured under in the West and in the Far East, Honorable Speaker. And some of these Far East countries, Honorable Speaker, you know, they have no standards. You get what you pay for. And it is that we sought to levy excise duty on, so that we protect that local manufacturer who is manufacturing sanitary towels in Mlolongo, another one in Ruiru, another one in Juja, another one in Nakuru, Honorable Speaker. It is the farmer in Western Kenya and Luo Nyanza, and parts of Nyanza, Honorable Speaker, that we sought to protect, who has now been given cotton seed, BT cotton seed, to produce cotton for the value addition of these manufacturing industries, Honorable Speaker. It is the Kenyan youth who are on the streets we sought to protect, to create jobs for them in those factories here, Honorable Speaker. But what did we do? We were told, reject. We rejected, we lost jobs. We rejected, we exported jobs to the Far East. No wonder, Honorable Speaker, today, when CS Mutua announces 3,000 jobs in Qatar, 30,000 Kenyans turn up at KICC. I want to plead with the Kenyan people, and more so our fourth estate, Honorable Speaker. Let us be responsible in how we communicate to our people, because we end up misleading our people, and at times even us as political leaders, we are guilty, because we end up saying what we think is popular with the public, but not what is right. And I've said here, Honorable Speaker, before, what is right is not necessarily what is popular, Honorable Speaker. Therefore, in terms of public participation, I want to ask all our committees, when we embark on public participation, our work is to listen to the views of the public and balance it against the legislative proposals that we have and against the policies that we seek to anchor that legislation on, Honorable Speaker. Because it is only you who, upon being elected, like the member for Kajiado South, the people of Kajiado South believe that the member of Kajiado South is the best amongst their people, Honorable Speaker. And therefore, because he's among the best of Kajiado South constituents, they entrust him to come and make laws on their behalf. And therefore, they expect the member for Kajiado South or the member for Kikuyu to know better. And by knowing better, to be able to know this legislative proposal that is before the House is anchored on the policy of import substitution. And therefore, you must balance the question of import substitution, the policy of import substitution, against the legislative or the tax proposals being made vis-a-vis the interests of business people who are importing cheap products that endanger our women, our young girls, Honorable Speaker, and it is only these honorable men and women in this House who can do that. Therefore, in conclusion, Honorable Speaker, let me inform the minority leader that indeed the office of the Attorney General is in the wee hours of finalizing on the public participation bill, a substantive bill that now, even further informed by what the Supreme Court has said, will guide our public participation exercise, moving forward, Honorable Speaker, so that we do not find many of the statutes that we enact into law in this House and in the other House, Honorable Speaker, being rendered unconstitutional on the basis of public participation. With those few remarks, Honorable Speaker, let me conclude by commending the honorable ladies and gentlemen in the Supreme Court who rendered that judgment that was very well informed, and we can now comfortably say that that Supreme Court has men and women, Honorable Speaker, who weighed in on the issues that will guide our country very well moving into the future. Thank you, Honorable Speaker.
Thank you very much, Honorable Speaker. Honorable Speaker, I also want to join my colleagues, the minority leader and the majority leader. Number one, in commending and appreciating the judgment made by the highest bench, the Supreme Court, as far as public participation is concerned, Honorable Speaker. Honorable Speaker, there was, like the minority leader has said, this can only be related to a study in jurisprudence, Honorable Speaker, that you and I know on a particular case. We call it the Spelunchian Explorers case, Honorable Speaker, and you and I know that very well, where because of lack of written law and quality jurisprudence that would have either convicted or acquitted the explorers, the Spelunchian Explorers, Honorable Speaker, there arose confusion in the bench where we found the Chief Justice hardly making decisions in that case. We found a positivist in the bench, I think Justice Keane. We also found a clear naturalist and one who even never wanted to touch. This question of public participation, Honorable Speaker, has brought a lot of confusion within our high courts and within our courts, Honorable Speaker, where one judge's view in the High Court in Kajiado, another judge's view in Kisii, another judge's view in Kerugoya, another one in Mombasa, and another one in South Mogrango. Very soon we'll get a High Court in South Mogrango. We are lucky to have a magistrate court so far. Honorable Speaker, when you read such laws, you will then be left wondering, and this House will be left wondering, which particular judgment would you, want to refer to when creating your own jurisprudence in terms of making the public participation worthwhile, Honorable Speaker. And that is why it is very important for this Supreme Court to have come with a clear distinction on what this House on what this House ought to do in terms of public participation. Because, Honorable Speaker, I was mesmerized by definitions of what a quality. I read one judgment that says what was a quality public participation. The parameters one created. What we are suffering from, Honorable Speaker, is actually what I will call judicial activism, where some people, and I say this with tremendous respect to members of the judiciary, where some members of the judiciary, Honorable Speaker, decided to be activists and populists, start making populist decisions. In fact, you'll be forgiven if you actually predict the outcome and then it comes exactly as it is, because you would see conversations on social media on how a judge would interpret this public participation direction, and the following day when you read that judgment, it is as exactly as it was written by some people on social media. This is mere judicial activism, Honorable Speaker. And the direction the Supreme Court has actually given us as far as public participation is concerned, it is a right jurisprudence. But again, I challenge this House to expedite the process of creating this law on public participation and create parameters. In as much as now we are using the jurisprudence that has been created, Honorable Speaker, it is important for this House to expedite such laws, and I think the chairman is here and is well noting, and then we expedite such process so that we do not have such similar confusions in future, Honorable Speaker, where the same procedure used on a particular bill is rendered mute, while a similar procedure that has been used on a different bill has gone through a similar procedure, passed and enacted, and it's now law. That kind of confusion, Honorable Speaker, couldn't be explained. We had lost quality on making our jurisprudence in courts, and we really must commend the honorable judges for coming up with such very serious directions as far as this jurisprudence is concerned. Thank you very much, Honorable Speaker.
Justice and Legal Affairs Committee.
Thank you very much, Mr. Speaker.
I've not allowed you to speak. Yeah, it takes the speaker to recognize you. When the speaker doesn't and you insist, you become disorderly and it may cost your presence in this afternoon. Yes, so you are not yet recognized. Let Honorable Murugara proceed.
Thank you. Thank you very much, Mr. Speaker. Mr. Speaker, the issue of public participation is a very important issue in this country. And we allowed the Supreme Court for the interpretation and the guidance it has given to the House and to Kenyans as regards what exactly is public participation and to what extent should this House consider views collected from the public during public participation. Indeed, it is true, many people think that when we go for public participation, we should be collecting views and votes from the public, so that if the public votes against whatever it is we are proposing, then it fails. Nothing is far from the truth than that, because the fact remains public participation is purely to ensure that our public is well informed as regards the legislative proposals we have here or whatever action Parliament is taking, so that the public does not plead ignorance at any time. Two very important things to say. JLAC has two drafts of Public Participation Acts, which we are looking at. In fact, we had scheduled December to be our deadline, so that we are able to produce something for the House to look at. But we are happy to hear the Leader of Majority saying they are also working on an Act of Parliament, which will be coming to us in due course and which we will be debating when the right time comes. Because part of public participation is the question which recently, on Monday, the newly appointed Deputy President of the Republic of Kenya, Professor Kithure Kindiki, posed to the judiciary. What is the difference between public interest and national interest? And which of the two is higher than the other? Because as far as public interest is concerned, and that goes with the public participation, there may be an element of mobilization towards rejecting a popular idea of the government. Is that what you should be calling public participation and the public interest? Or we should be looking at the bigger good of the country, what is beneficial to the country, and we should be carrying that as actually what entails public interest. All this is going to come before the House. We have to prepare ourselves so that we can enact one of the best laws in the country, guided by the judiciary, so that we produce an Act of Parliament on the public participation which is acceptable across. Thank you very much.
Honorable Kimani Kuria, you want to speak to this? I hope you are not laying. Okay.
So, Honorable Chair, Honorable Speaker, I want to join my colleagues in celebrating the Solomonic wisdom of the ruling by the Supreme Court of the Republic of Kenya. Honorable Speaker, the reason why the finance bills for the last 2 years have become a subject of discussion in the whole country is because the Departmental Committee of Finance and National Planning made a deliberate decision that we would engage members of the public to seek their views and to have their voices heard on the matters that are going to affect their lives and matters that are going to affect our economy, Honorable Speaker. I, however, noticed, Honorable Speaker, that during the process, perhaps what we should have started with was civic education on what is a lawmaking process and how is a lawmaking process done. Because, Honorable Speaker, we saw even very educated people display their ignorance on the process of lawmaking. Honorable Speaker, I dare say that we had one of the most progressive reports that the Finance Committee of Finance and National Planning Committee tabled in this House, and this Honorable House approved at the third reading. The issues that members of the public were raising had sufficiently been addressed in our report. And how we are finding now, Honorable Speaker, now, is that those matters that should have been passed in, for example, reducing the weight of taxes on payslips by making these statutory deductions like SHA and housing levy become tax allowable for payee, were matters that we had considered. Honorable Speaker, we have thousands, if not millions of Kenyans that were locked out of tax amnesty, a matter that we had considered and extended the tax amnesty to next year, where we are saying you pay your principal tax, or you have a commitment to your principal tax, and you have your interest and penalties all forgiven. But, Honorable Speaker, these matters were left, and we are hoping that as we consider several other legislative proposals that are coming to this House, that both the House and the members of the executive should consider civic education. And I'm happy because even our civil societies and our activists and even upcoming politicians have now taken upon themselves to understand how laws are made in this country. Honorable Speaker, even as we had the previous discussion about the impeachment of the Deputy President, there were questions about comparing how the process of assumption of office of a Deputy President was compared to that of the President of Botswana. Honorable Speaker, the difference is we have our 2010 Constitution, we have several laws in this country that spearhead such a program. And until a time when we change our Constitution or we change those laws of Parliament, those particular statutes and laws, then that will be the procedure. And therefore, I'm urging Kenyans that during the various respective legislative proposals that are coming to this House, the bills that are coming to this House, let us follow our Constitution, let us follow our laws to do it according to the laws of the Republic of Kenya. And let us take time to understand the lawmaking process, because unfortunately, we have no shortcut, because we must adhere to our 2010 Constitution as passed by the majority of people in this country. I beg to submit, Honorable Speaker.
As I will only give 2 more members the opportunity to comment, then we can go back to main business. The Deputy Majority Leader, to be followed by the Honorable Beatrice Elachi.
Give me the mic. Honorable Speaker, thank you very much for giving me the opportunity. I want to weigh in what the Honorable Junaid has said about the ruling at the Supreme Court. Honorable Speaker, I want to say this, that the Supreme Court actually asserted the doctrine of separation of powers. The doctrine of separation of powers. The Supreme Court, what it has done is to say Parliament has work cut for itself, allow Parliament to do its work. The judiciary has work cut for itself, allow the judiciary to do its work. And I think this is a landmark ruling, Honorable Speaker, delivered by the Supreme Court. And this ruling will allow this country to move forward, government programs to move forward. Otherwise, the article on public participation became the Waterloo in the Constitution itself, because the Constitution could not move forward, implementation of laws could not move forward, because it was always taken back by the issue of public participation. Honorable Speaker, if you allow me to say this, the High Court has continuously abused Article 165, 3D1 of the Constitution, which says that the High Court has jurisdiction on the interpretation of laws, including whether the law is consistent to the Constitution. That Article 165, Honorable Speaker, has been abused by the High Court in such a way that they became a supervisor of the legislature. which is not the role of the courts in this country. The courts cannot be supervisors. They have been given the mandate in the law, Article 165, to check and interpret to the extent to find whether the law is actually inconsistent with the Constitution. And I want to say this: the separation of powers must be respected. Parliament must be given opportunity to work, and this Parliament cannot be supervised by the whole High Court, but the High Court has a role to ensure what we pass here is consistent to the Constitution. Honorable Speaker, they picked the issue of public participation and wanted every law to fall on the sword of public participation. But I want to thank the ladies and gentlemen at the Supreme Court for asserting that we need to give Parliament an opportunity to work by actually giving that ruling, Honorable Speaker. I think Parliament and the nation. Otherwise, I would also say we also need to ensure that the courts do public participation on every ruling that they want to make, so that it becomes cross-cutting. But I want to join Honorable Junaid for bringing this up, Honorable Speaker, and I want to thank the court and the Chief Justice for ensuring that now the issue of public participation will not be allowed to continue to abuse the authority of Parliament. I thank you, Honorable Speaker.
Honorable members, we need your numbers. For those who are leaving, we want to request for your patience because we need your numbers in order number 8. You remember we re-altered the order paper, awaiting some good numbers. So may I request that we allow Honorable Beatrice Elachi to say something to this, then we go back to the orders which require your numbers. We ask for your patience to stay within.
Thank you, Mr. Speaker. Mr. Speaker, let me also appreciate our minority leader for bringing this matter. Mr. Speaker, for me, I want to thank the Supreme Court because they've gone back to the act of the Supreme Court. That indeed the purpose of why we had the Supreme Court in this country, and we really wanted as an aspiration for this country, was which court will be there for public interest. And when you look at the objects of the Supreme Court Act, it is very clear, especially at C, that they need to develop rich jurisprudence that respects Kenyans' history and traditions and facilitate its social, economic, political growth. And Mr. Speaker, when you look at all the cases we've gone through, one of the things that the High Court has always disregarded is public interest. What is this good? You find that in a judgment, Mr. Speaker, this is the same arm of government that has already received resources, it has spent that resources, and then you nullify the whole bill. But you are an arm of government that is spending also. And then there you wonder, what just happened in our country? So for me, we have gone through a rough time of public participation. Until the last one of Kerugoya, we had to go now to constituencies. At least we've come now to an agreement of both arms that indeed you need to notify, you need to ensure. Remember, Mr. Speaker, Kenyans are not the type where you will force them to come for public participation. And some will come and they will want you to facilitate them also to go. So it is not something they come willingly. So it is something that has really hurt many of the decisions that we have made. But also, just as I said in the morning, there is need also now we speak to the Senate. Because most of these cases, it is not about the courts. It is about us ourselves taking each other to court, which we have to now rethink. But lastly, we need to go back to court to appeal also the case of CDF to the Court of Appeal. As much as we know we are going to change it, it is important to appeal that there is a court that will understand for public interest, a law that has been there that has served for more than 25 years. What else can you do if you are a court? And when you look at that judgment of NCGDF, you wonder where the judges were reading. It is absolutely very unfortunate, that judgment. And so how I wish we can go back and relook at this judgment we were given on NCGDF and deal with it once and for all. Thank you, Mr. Speaker.
The Honorable Mwengi Mutuse. Ecomas Mwengi Mutuse.
Thank you, Mr. Speaker, for the opportunity to contribute on the important question that has been brought by the Honorable Junet Mohammed. To my understanding, Mr. Speaker, Supreme Court is a court that is supposed to balance between philosophical, technical, and political interests of a country. And if you look at the historical foundations of the creation of Supreme Court right away from America, you realize that it is a court that is supposed to create stability in a country. And therefore, for that particular purpose and for that historical understanding, allow me to join the rest of the members of this House in congratulating our judges of the Supreme Court in so far as balancing the philosophical, technical, and political interest in determining the place of public participation in our governance system. Having said that, Mr. Speaker, and having had a cursory look at the decision of the Supreme Court, I realize that the Supreme Court did lay grounds, factors, and the test that is to be relied upon in terms of initiating public participation for legislative work and for decisions on policy matters, in terms of how those decisions are going to be processed through the legislative system, but also importantly, the test upon which courts of law are going to use to determine whether public participation indeed has been applied satisfactorily, both qualitatively and quantitatively. And therefore, the invitation to this House to enact swiftly a law on public participation is most welcome. As my chairman, the Honorable George Gitonga Morogara, has said, in the Justice and Legal Affairs Committee, we had begun to look at ways of closing this gap because we were also aware, as a committee of the House involved in matters justice and matters law, that we cannot continue having a legal lacuna in terms of public participation. Because, as members have aptly put it, a lot of legislation very good for the country has been shot down because of misunderstandings. Just different judges reading from different scripts as to what is the place of public participation. And I will therefore be very supportive when finally the state publishes the public participation law in line with the decision of the Supreme Court. But also importantly, Mr. Speaker, as this House considers the question of public participation, we may also need to consider the question of a referendum law, because hand in hand with public participation is the place of a referendum in our governance system. And therefore, we'll be also urging the majority leader to also liaise with government, so that even as we enact a law on public participation, we also enact a law on referendum, so that the country is adequately resourced legally to deal with these two issues. I thank you, Mr. Speaker, for the opportunity to contribute. And I want to assure the House that having successfully impeached a Deputy President, I am not going to impeach any other person soon, because we cannot go lower than that. Thank you.
I think we allow the members who have spoken to the matter to speak on behalf of the whole House. Call order number 8.
Order number 8, motion, report of the Committee of the Whole House on the Kenya Drugs Authority Bill, National Assembly Bill number 54 of 2022. Question to be put.
Yeah, honorable members, I order. Honorable members, I now put the question that this House do agree with the report of the Committee of the Whole House on its consideration of the Kenya Drugs Authority Bill, National Assembly Bill number 54 of 2022, up to clause 79, and seek leave to sit again. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? The ayes have it. Next order.
Order number 9, motion, first report on the implementation status of House resolutions on committee reports and public petitions. Mover to reply.
Again, the chairperson of the Committee on Implementation to reply as briefly as possible. We want to put the question to this one.
Thank you, Mr. Speaker. I beg to reply, and I want to thank the honorable members for their contributions, Mr. Speaker. And the most important thing that I want to ask those ministers and departmental heads, Mr. Speaker, that when they do budgeting, they need to include some money to enable the implementation of some of the resolutions, Mr. Speaker. Mr. Speaker, I want to donate only 2 minutes to Honorable Mwenje.
The Honorable Raphael Wanjala, Chairperson Committee on Implementation. If you intend to donate, you donate before you reply. So unfortunately for those members, they have been overtaken.
Okay, Mr. Speaker,
So just
I reply. I beg to reply.
Thank you very much. Honorable members, let me also put the question to this. Honorable members, I now put the question that this House adopts the first report of the Select Committee on Implementation on the implementation status of the reports on petitions and resolutions passed by the House, laid on the table of the House on Thursday, 26th October 2023. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? The ayes have it. Yes, we had reorganized the order paper. Can you go back to order 7? Order number 7. Yes, we pended the laying of order papers and some statements. The Chair, Departmental Committee on Finance and National Planning.
Thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House today, Wednesday, the 6th of November, 2024. The report on the Departmental Committee on Finance and National Planning on its consideration of the Equalization Fund Administration Bill, Senate Bill number 14 of 2032.
Thank you very much. Please lay. Do we deal with these people? Yes, then the Honorable Peter Francis Masara, the MP for Suna West.
Thank you, Mr. Speaker. Mr. Speaker, first, allow me also to welcome the delegation from Suna West, NGCDF, both the committee and the staff who are today the guests of the August House. Mr. Speaker, I want to appreciate them and those who are not here for working so hard to make Suna West shine the way it is shining. Therefore, Mr. Speaker, allow me, pass it to the provision of Standing Order 43. I wish to make a statement regarding the untimely passing on a veteran musician, Mrs. Lilian Nauma, popularly known as Princess Julie Alili Nyajogina, on Saturday, 12th October 2024, while undergoing treatment at the Migori Referral Hospital. Honorable Speaker, the late Princess Julie was a veteran Luo Benga singer who hailed from Suna West and became popularly known for the viral song Dunia Nimbaya. The song